scared by this individual?
Oh, I can't recall. No, no.
Good afternoon, everyone, and welcome to the Law News Network. I'm Misty Maris, and I'll be with you today this afternoon as we go to Florida for the Toledo trial. Court is scheduled to reconvene at 1 p.m. where we'll be back in the courtroom live with testimony. The prosecution anticipated to rest today. But what have we seen so far? Well, this trial has had some twists and turns in that we saw a very lengthy interrogation video of Toledo where he actually says, "I killed my wife, but I did not kill her two children." An interesting fact, given that the defense opened up out the gate with what really is their strongest defense. You don't have a body, so how can you say that there's a murder? So interesting to see what happens next when the defense puts on their case and how they intend to proceed, whether or not they're going to call witnesses or they're just going to say, hey, look, the prosecution failed to prove their case beyond a reasonable doubt because they really couldn't pinpoint some of these key facts in proving a murder case. Yesterday, we saw some testimony by the sheriff who, with defense and cross-examination, did just that, undercut his testimony by saying, okay, well, you believe that Toledo killed his wife and her two children. Investigators said, yes, he killed all three of them. Defense said, well, what evidence do you have? Sheriff admits it's circumstantial, but for the confession to killing his wife. Interestingly enough, the defense attorney, as we would expect, says, all right, well, when did she die and how did she die? And those questions could not be answered. But is that enough, given the circumstantial evidence that we have in this case and some of the testimony that we heard today, which was a long recorded phone call between Toledo and a friend where he describes his jealousy. He doesn't admit to killing his wife in this call, but he does talk about how jealous he was. Is this going to be enough? Can the defense overcome all of these facts? I can think of no better person to discuss this with than Ken Belkin, our Law News trial analyst. Now, Ken, you're a defense attorney.
I am.
And I have a question for you. So, look, we've seen this
I'm
trial
not going to have a good answer for you, all right?
Well, I want to know,
this is not going well for the defense.
When you're talking about being a defense of a case like this, where, first of all, you have horrific circumstances. You have a wife and her two children killed. You have children involved, which is always tough for the jury because, obviously, that's sympathetic. These two kids lost their lives.
Yeah, absolutely.
You don't create the facts as the defense attorney. You just put forth the best defense. So my question to you, I'm interested in what you think about what's going through the defense attorney's head. Now, we heard the opening statements. Of course, no body murder cases. Tell us a little bit about those. Why is that a difficult case to prove?
I mean, what's going through this defense attorney's mind is probably death by 1,000 tiny cuts, because this is not a case that's going to win. I mean, Mr. Toledo, he's going down. He's going down. It's only a question of how far down is he going. Is he going for all three murders or just the murder of his wife? I think, look, we all know the standard. We've all seen the TV shows, proof beyond a reasonable doubt. What they don't show you on these TV shows is a very common instruction that the judge gives the jury. That proof beyond a reasonable doubt does not mean removal of all doubt. So they can still have some doubt, but they just shouldn't have a reasonable doubt. And as to the murder of his significant other, the mother of the kids, look, he confessed. He confessed. There's DNA blood evidence. There's circumstantial evidence of the teenage neighbors hearing the screams of this woman, screaming to help me. You know, there's a lot of circumstantial evidence. He's going down for that one. Now, for the children, it's a little bit tougher to convict on that. He doesn't confess to that. There is evidence of blood, you know, but there is nothing that directly ties him to their disappearance and murder. Also, as we've said many times, the classic no body, no murder scenario. There's no bodies here.
Right. But Ken, so let me ask you about that from a defense perspective, because the stakes are high in this case, and the stakes are high because the two children lost their lives. That's what's going to bring him to the death penalty. If he's convicted of the murder of his wife, he won't be eligible for the death penalty. But if it's the kids, then he will. Not that he will, we don't know if he would get it. Obviously, just because you're convicted doesn't mean you automatically get the death penalty. But did the defense almost drop the ball? Would it have been better knowing that a confession tape is going to be heard by the jury. Now, as lawyers, we know there's many ways to suppress that evidence. Perhaps the defense tried to keep it out, but there was really no good reason. But at some point, the defense attorney knows the jury is going to hear that he admits to killing his wife. Is there a strategic decision where you say, as a defense attorney, let's cop to it, self-defense, just like he said in that confession tape closer in time to when this happened? He said she was the first aggressor, and then I came back and she died and it was a mistake and all this. Well, and then try and get out of the murder of the children because there is less evidence. Do you lose credibility from the defense perspective when you have a confession tape and you're saying, well, we don't know how she died, when your client told the jury?
Well, yeah, first of all, he shouldn't be promising things to the jury in his openings that he can't deliver on throughout the course of the trial. You know, look, it's clear this guy confessed. It's very tough for a human being to hear someone confess to murder and then be like, oh, well, maybe he didn't do it. You confessed. Common sense is going to rule the day there. You know, look, there are no bodies. That's true, but the confession is very strong. The blood, very strong. The screams, very strong. I think the best result possible in this case is, you know, a life sentence and avoid the death penalty, because I don't think that there is enough evidence, circumstantial or otherwise, to tie him to the murders of the two children.
Right, and he also, in that same confession tape, which again, these are the things that as a defense attorney you're really thinking about, because you don't want to contradict yourself. You don't want to say, believe my client in this confession tape on the point that Tyshawn killed the kids, but don't believe him when he says that he killed his wife. It's totally contradictory. You're either going to believe him or you're not going to believe him. So when you're talking about, of course, in a case like this, with any defense, you don't have to point to another person. You don't have to say that it was this person that did it and prove that. You can propose alternate theories and say, well, this undercuts the case, so you can't prove the death of the kids beyond a reasonable doubt. Look, this guy Tyshawn, he came with him in the middle of the night to this parking lot to dispose of some of this stuff. He never asked any questions about what they were doing there. I mean, obviously, there's a little bit of a question mark in the jury's head. You're going on this midnight run and throwing stuff at a dumpster and cleaning a car, and you don't inquire as to what you're doing. So perhaps Tyshawn would be someone that could be used as reasonable doubt, but isn't it almost an oxymoron to say you believe him that it was Tyshawn in this case, but not that he murdered his wife in this fit of rage? I
mean, look, I don't know that there's enough evidence to prove beyond a reasonable doubt the murder of the children. I still think the jury's going to convict him on it.
Because in some sense, when you're talking about...
He participated in some
capacity.
Some capacity, he participated
in any case, because he did, even by his own test, or the investigation tape, in some way he knew about it, participated in it, and all of that. But that's why I agree with you. I think the problem, well, there's a lot of problems for the defense with this case, let me say that, but a bigger problem for the defense is that promise that was made at the beginning of the case that, hey, look, well, there's no body. Well, we don't know what happened. We don't know when it occurred. When you know later in the trial, you're going to hear, the jury is going to hear your client say, this is what happened.
For that very reason, I'm extremely shocked that they weren't able to resolve this with a plea deal.
Which would be, if you say, perhaps a lower level of murder, heat of passion, you could say self-defensive if the facts permit, as that would maybe be a viable argument under the facts that we know from that interrogation video, that the defendant said, she came at me first, she was the initial aggressor, I punched her and she died, fine. And then maybe take the kids off the table.
A deal that gives this guy 25 years is probably a win, considering the weight of the evidence.
Right. So perhaps the prosecutors, we don't know that. We don't know what happened at the beginning of the case. Maybe the prosecutors weren't willing to cut a deal. They have some decently strong evidence against him, including a confession as to her murder. And then you've got two children, which is just so terribly tragic.
The media coverage, puts a lot of pressure on them. They don't want to give the perception that they were being light on this guy.
Right.
They want to be strong, elections.
It could be. You're right, and absolutely. And maybe that's why we didn't see a plea deal, because it seems like one that the defense attorney would come in and say, look, let's sit down at a table and see if we can hammer something out.
25 years is a lot better than lethal injection.
Absolutely.
Maybe.
Maybe depending on where you go, I suppose.
Your disposition.
So what about this other fact? So say somehow during the course of the defense case, because we don't really know where they're going to go when the defense starts putting on their case, and if they're going to try and contradict that confession in the interrogation video. I don't know what they would do. I don't know how they would do that, but we'll see. Only time will tell. But what about the fact that after this interrogation, you have Toledo going into the bathroom and attempting suicide? I mean, that is obviously something the defense vehemently tried to keep out of the trial. Prosecution says speaks to his guilty mind. Jury ends up hearing it. I mean, that's a little bit.
I don't know that
of
it
a tough
speaks
fact.
to his guilty mind.
Well,
I don't
it got
necessarily.
in on those
I know.
grounds.
I don't agree with that ruling. I think people under very stressful situations, being accused of murder, probably being one of the most stressful situations a human being can endure. It really pushes you to your limit and tests you. And I think a lot of people crack under that pressure. I'll tell you this. This is a classic case of you're being interrogated by the police. You should probably be invoking your right to counsel at this stage. But a lot of times, people do not do so.
Right, and it seems, I mean, this was a very long, we watched the whole thing here on the network. It was a very long interrogation, and it did come, there several stories came out. So again, you have that credibility issue in believing what the defense is telling you in the interrogation video, story number one.
And by the way, had he invoked his right to counsel, and this interrogation video would be a moot point, and I don't even know that he would have been charged.
And you might be right, Ken. And again, there's a PSA for everybody. If you ever find yourself in a situation, make sure you get your attorneys involved, because this confession in the interrogation video, coupled with just the changing of the stories, it really undercuts the defense case. Not that there wasn't other circumstantial evidence out there, but maybe this is what tips the scale. First, you have him saying, my wife and I got into a fight. And because of the affair that she was having, so I got into my car and I drove and I spent the night in my car alone. And I didn't go and see anybody and I didn't talk to anybody. Slowly that evolves into I went to my brother's house. Conveniently, that time frame fits in with...
little by little,
right,
it
little
leaks
by
out.
little it leaks out, and then eventually leading to, well, yes, I killed her, but it was in self-defense. How do you recover from that as a defense attorney?
You don't recover. And you hope that when you're facing a case like this, that you have a client that does invoke his right to counsel and calls you, and you take that 2 a.m. ride down to the police precinct to let them know your client won't be answering any questions.
Exactly.
It's so crucial, and people don't even realize. By the way, even for people who are not guilty, being interrogated by police, the police are permitted to lie to you. It's not illegal for the police to lie to get you to make a statement that incriminates yourself.
Right, absolutely, and it can be stressful. We know, and I'm a defense attorney myself. I've defended a lot of people in a lot of different circumstances, and very often you find somebody who says, well, I just signed it because I thought I would get to go home or something afterwards.
Yeah, they told me they'd give me a ride home.
Right.
to your new home.
Yes, to the penitentiary,
yeah.
Yes, and that is oftentimes the case, and sometimes you can keep some of those confessions out. Sometimes you can really undercut the confessions in court, in trial, if you have those circumstances where someone's just being hammered. In this case, I think you've got a tricky situation having watched the interrogation video where you do have those evolving stories.
Yeah, it's not good. This guy is going down. I've said it from the beginning. This case is a hopeless case for the defense attorney. The best result here would be keeping him alive.
Right. So now let's talk about Tyshawn Jackson, because the finger pointed pretty quick at Tyshawn Jackson by the defendant. Once he said, I killed my wife in self-defense, she was the initial aggressor, but I did not kill the kids. That was Tyshawn, my neighbor. Tyshawn, again, just to review for our viewers, Tyshawn is the neighbor who testified that he was that Toledo tapped on his window in the middle of the night, and then he followed him in his car to a parking lot where some items were disposed. The car was cleaned, and certainly some damaging testimony by Tyshawn Jackson against Toledo. Now we know Toledo indicated that Tyshawn Jackson was the person who killed the kids. What do you make of that, Ken? Is that going to go anywhere?
We know that Toledo says Tyshawn Jackson killed the kids. Toledo's probably thinking, I'm not such a bad guy. Yeah, I killed my significant other, but I didn't kill the kids. No, Tyshawn did that. I mean, at this point, I don't know what you'd have to be smoking to believe anything this guy says.
Right. He's lost a lot of credibility. We do see where the defense was going with Tyshawn, though, when we heard from an investigator yesterday. During the defense really talking about Tyshawn Jackson and whether or not he received favorable treatment during the course of the investigation, perhaps insinuating that Tyshawn's testimony might not be on the up and up for the purposes of protecting himself. If you take any credence in Toledo's version of the facts where Tyshawn was responsible for the death of the kids, clearly the direction that the defense was going. Let's watch that testimony now while we wait to come court back in session.
It's about something that law enforcement did and speaking to a judge. Could you explain the entire situation for us, please?
Yes, sir. Mr. Jackson had a court date that, again, this is going back a while. I want to say it was the 24th, 23rd or 24th. Hello, my fellow brother. I hope and pray that when this letter reaches your hands that it finds you and the family in the best of all health, body, mind, and soul. And may the Lord hold you in his care. It has been a long time since we have spoken, and you, Ivan, and George were the only people that I ever spoke to and bring my problems to. I always looked at you there as not only friends, but my mentors, and I learned a lot from you. There that I will always carry with me until the day I rest in the Lord's hands. The fellow inmate told me that you was one of his potential jurors for his trial, and he told me what you said about me, and it brought tears to my heart to know that you feel that way about me and believe in me still. I wanted you to know that you are right, and what they are saying that I did is not true. I would love to tell you step by step of everything that happened that day and night, but I can't because everything I say can be used against me. I want you to know that I never hurt or touched my kids in any way and never could. I love those kids more than anything and still love them till this day. I was very hurt by what Yesenia did of cheating on me and sleeping with that Marino from her job. But even that could not drive me into doing something like that. You all knew how tough and brava Yesenia is, and was quick to hit me sometimes, but I never hit her back. No matter what, I always kept my cool. It hurt that she stopped allowing me to hang out with you guys, and how she stopped us from going to church, all because she didn't like certain people. But look at the end. The truth came out that she was doing dirty and sneaky things behind my back. I'm being strong, Juan, because I have a lot of peace now and a stronger relationship with God. I read my Bible day and night, and I've learned so much that it brings tears to my eyes. I don't worry about what will happen to me and don't even care anymore. Whatever the outcome may be, I am ready. Whether it's the death penalty or life, I am ready and not afraid of either one. The way I walk now, no person or justice system can take that away from me. They can have this body and do as they want with it. But my soul belongs to the Father and true God, Jesus Christ. Then it goes to Spanish. The translation is, I have a very big surprise for the world. I have many friends that owe me favors. Between you and me, I sent 3 boxes to Laredo, Texas, 1 large and 2 small. Large one has already been sent to Veracruz, Mexico, and both are good or taken very good care of. Now you know why I don't care about what they do to me, because my things are good. And then back to English. Pardon, because I know I can't spell Spanish good, LOL. I really miss my kids a lot, Juan, and I have them a lot. I love them a lot. I am the only father they know. I could never ever hurt them, Juan. So what they are saying about me is not true, and I ain't no monster. I really miss all you guys and miss going to church and talking with all the juvenines. Send my love to my good friends George and Judy. Tell them I love them and that I would write them, but don't have their address. And also the same to Melissa and Ivan. And can't forget your wife Karen. Also ask Karen if she has the photo of my wedding. If she does, can she send them? Also, you can only put 6 pictures per envelope. Sometimes I wish that this was all a big bad dream, but it's not, and I wish that if she would have just been honest with me about wanting to be with other men, I would have never married her. And it goes to Spanish for now you can fuck as much as you can in a whorehouse. Send my regards to Pastor Lopez. And then back to English. And take good care of yourself. Hope to hear back from you one day. Thank you for everything you have ever done for me, and I still cherish all the good times we had together. We will one day see each other again, whether it is here or in the kingdom of heaven. God bless you, my brother. Love you all. Love always, Semi. P.S. in Spanish. Don't tell anyone I wrote except George and Ivan. I don't want Yesenia's family to speak ill about you. They're gossipers. That's it.
About something that law enforcement did in speaking to a judge. Could you explain the entire situation for us, please?
Yes, sir. Mr. Jackson had a court date that, again, this is going back a while. I want to say it was the 23rd or 24th, that he was supposed to go before the judge. Mr. Jackson was with us, assisting us with the investigation, talking with us, taking us the driving route and such. And we were not aware that he had this court date until after he had missed it. Once we became aware that he had missed the court date because he was with us, it was essentially our fault. That's when we took him up before Judge McGlashan and advised Judge McGlashan that it wasn't Mr. Jackson's fault. He was with us, and essentially we apologized.
Will a court sometimes issue a warrant for a person if they fail to appear at a court date?
Yes, sir.
Were you aware that this was a misdemeanor pot charge, that he failed to appear on that day because he was with you?
I don't recall what it was, but...
Okay. But the balance, were you aware that he failed to appear because he was with you?
Yes, sir.
And did you personally ask the judge not to issue the warrant and surrender Mr. Jackson on that day to the court?
Yes, sir.
Did he satisfy his condition of appearance in your presence?
Yes, sir.
And did the judge conduct court with him and release him back to you?
He talked to him for a few minutes and released him back to us, yes, sir.
And so essentially, what favor was granted to Tyshawn Jackson in this case?
Just not issuing the warrant.
Judge, I don't have any other questions.
Thank you. Kenny Recross.
Bottom line, Mr. Ford, on that situation, taking him to court, you didn't have to do that, correct?
No, I didn't have to take him to the court.
Okay, you could have easily just said, hey, that's your problem, you deal with it.
We could have.
Okay, all right, thank you.
All right, any redirect?
Hello, everyone. Thank you for joining us on the Law News Network. I'm Misty Maris. We're waiting for the Toledo case in Florida to be back in session. We anticipate that the jury will be back in the courtroom around 1 p.m., where we'll hear what we think will be the prosecution finishing up their case and then moving on to the defense case. This morning, we heard some audio of a prison call between Toledo and a friend where Toledo talked about some of his jealousy relating to his wife, but did not confess to the murder or anything like that, but definitely was talking about how he was very jealous and certainly probably not helping his case in that sense. We also were just reviewing some clips from some prior testimony. What we just watched was the investigator talking about Tyshawn Jackson. This was the defense attorney trying to undercut some of the evidence relating to Tyshawn Jackson. Of course, we saw Tyshawn Jackson testify that he assisted in something in the middle of the night after the disappearance of Toledo's wife and the 2 children, where he didn't really know what he was doing, but he followed Toledo in a car to a parking lot where they cleaned the car and threw some stuff away in a dumpster. Tyshawn Jackson's testimony was he never really asked what was going on or what he was doing. Some doesn't really sit well with a lot of people, a lot of our analysts here, and myself included. That doesn't quite sound right. And we saw the defense trying to capitalize on that a little bit because Toledo had pinned the murder of the 2 children on Tyshawn. So now, in that past clip, we see the defense inquiring as to whether Tyshawn had any sort of special or favorable treatment by law enforcement because perhaps he was cooperating with law enforcement and the prosecutors to with respect to the testimony against Toledo. So to break this down with us, we have Ken Belkin here, LawNewz trial analyst. Ken, do you think that they succeeded in any way on undercutting Tyshawn Jackson's testimony? I mean, to me, I don't find it believable that somebody taps on your window in the middle of the night and you say, oh, yeah, sure, I'd be happy to drive with you to this parking lot and, assist in cleaning your car out. Well, that doesn't seem right to me.
I'm a little discouraged to hear that, Missy. I guess I'm not going to be calling you at 2 a.m. if I ever need to dispose of a body.
Perhaps you'll have to find another conspirator to help you out with that.
Look, at the very least, if you were to help me, at least there's a good chance you might be called as a prosecution witness and be offered a great cooperation deal.
Yeah, you never know.
As this guy has been offered. Look, I think the prosecution would have loved to get this guy as a co-defendant and treat him as, as he should be treated, as he should be prosecuted if he aided this guy. But evidence didn't work out that way, and the evidence worked out in his favor. They didn't have enough evidence without his testimony.
Right, but Ken, couldn't the prosecution have charged him as an accessory after the fact?
Yeah, but, then they wouldn't have gotten Mr. Tyshawn Jackson on the stand to testify against Toledo because the 2 defense attorneys would probably start working together on their strategy.
And you're probably right about that. We don't know what happened prior to the trial, if he was threatened with prosecution or something of the like. I'm pretty sure that it isn't necessarily, or you could put this before the jury with respect to Tyshawn Jackson when you're talking about accessory after the fact. And a jury is not going to buy that he had no clue what was going on. Something about that just doesn't seem right.
Someone knocks on your window at 2 a.m., asks you to follow them with your car and clean out blood from your car. No questions, Tyshawn. No questions. Just get me some In-N-Out burger and I'm good. Yeah. No questions. Yeah, I find that very hard to believe.
Something is a little bit strange about that, but
yeah, and I'm pretty sure Tyshawn is not on that stand willingly.
Yeah, probably
he would not be there.
Probably not, and you're probably right about that. And we don't know what happened prior to, but we know that his testimony was pretty damaging to the defendant. Although I think the most damaging is still the confession tape. I mean, you've got the person, the defendant, the guy who's sitting at the table saying, yeah, I did it, but it was self-defense. And we didn't hear the defense attorney start with that at the beginning of the case, and I think a jury's not really going to like that. Now, couple that with some of the other facts that came out in this case, and this is when the defendant actually confronts.
Well, hold on. By the way, if it's self-defense, maybe you shouldn't go on to say in that video, you'll never find the body. Because it's self-defense. Presumably, you might want to try and introduce some forensic evidence of self-defense.
Oh, yes. And if you were going to argue self-defense, then obviously you're going to need to say that you did it, right? And the circumstances surrounding what happened, and as you said, some sort of forensic evidence. And in this case, Toledo, obviously, if he did it and he killed her, that he also disposed of the body. So now you've got even more problems on your hands, which is perhaps why the defense attorney went with the old no body, no murder theory of the case. Well, you don't have the body, you can't pinpoint when, where, and how this happened.
I mean, this defense attorney's strategy is like something you would expect to see in a movie of a guy who's clearly going to jail and losing.
Right.
But it's not his fault. This is a bad case.
It's a bad case. I guess I don't understand the strategy yet. Maybe I'm jumping the gun because we haven't seen the defense put on his case, and perhaps something in the defense case will tie this up or make it make sense or somehow put it together. We really don't know.
I think his strategy is to get through the case with some of his professional reputation intact.
That's certainly true. I mean, this is not a great case for the defense. And again, it's not, you're right, it's not the defense attorney's fault. You don't make up the facts. You're dealt the hand you're dealt. You put forward the best defense possible. Ken, I agree with you. I think with respect to the kids, there's not a lot of evidence. But if the jury believes that he killed his wife, are they going to make that leap? Are they going to be thinking about it enough?
By the way,
that they're not going to make that leap that he killed the kids too?
It was self-defense. I was scared of her. I had to defend myself and employ lethal force and kill her kids.
Yes, and where, if
You're
you
defending
know Tyshawn,
against the kids too? I mean.
Yeah, and if you know Tyshawn killed the kids, say hypothetically, this is his story. His story in that tape is, well, yes, I killed her, but it was in self-defense. It was Tyshawn who killed the kids. Then,
but you're so hung up on self-defense. Maybe you could have defended the kids when Tyshawn was killing them. There's a lot of stupid questions.
We're really on the same page. There's a lot of circular logic.
A lot of, yeah.
All right, so let's talk about another fact that I found to be pretty interesting, and that's that the day before this family goes missing, you have Toledo showing up at the victim's office to confront her lover. Now, she was having an affair. He found out about it, and he comes to the office, confronts a coworker, calls 911 because they're scared. We heard the tape played in court. Now, we didn't hear any, we know that on the tape she didn't say that there was any sort of physical altercation, but there was something going on where there was yelling, and you heard all that in the background, big commotion. What do you think that factors in? How does that factor into the case?
Well, that actually raises a very interesting legal point and distinction between at least Florida and the state we practice in New York. Look, I've had a ton of clients who have done that. Exact same thing. Shown up at the lovers, the wife has an affair with someone they work with, shows up at the workplace, creates a big scene. Now, in Florida, that didn't result in him getting arrested because they don't have a mandatory arrest policy for domestic violence incidents. In New York, you better believe every one of my clients who's done that has been picked up and arrested immediately.
Right. So they didn't have that, or they didn't have to. They had discretion there, I suppose.
Yeah,
they could have arrested him.
They had discretion, but in New York, they do not give discretion for domestic. In New York, the police have discretion whether or not to take you in custody and arrest you on anything from a Class C felony or below. Otherwise, they could issue a desk appearance ticket, with certain exceptions for drunk driving, obviously, and for domestic violence incidents. And that's because the legislature years back decided to get tough on domestic violence. It was a big problem. Some people argue that maybe they got a little too tough on it. So there's got to be a middle ground. But Florida, there's no mandatory arrest policy for domestic
which is
violence.
Interesting. And you're right, in New York, and obviously it's supposed to be a deterrent effect, a way to keep people from going right home and engaging in some sort of violence against their spouse.
Chill these guys out, or gals, whatever the case may be. Don't want to be sexist.
Right.
But, and clearly this is exactly the situation that these laws in New York were meant to address. The situation where the guy creates a scene and they got to take him into custody so he doesn't do something worse.
Right, and we know that that's a problem in general. When you're talking about domestic violence, it's that escalation. Yep. It goes from some sort of altercation like you just described, or like we see in this case, to something much more violent, which it appears that something happened here. And that's really what's at issue, and understandable why they would have that law. Now, interestingly enough, as you said, the police chose not to arrest him in Florida.
Yeah.
So here's another question, just for now that we're talking about just hypothetical legal issues. So in order to say that you acted in the heat of passion, from a defense perspective, the defendant acted in a heat of passion, upset, found out about an affair, and just lashed out, and get that as a mitigating factor so you're charged with something less than murder one. Would this factual scenario fit into that? I know in New York you need, in order to succeed, you can't have an adequate period of time to cool off. You have to, it has to be
He
close in
presumably
time.
had 24 hours to cool off. Also, you know, I don't know that there's any premeditation here to get it to first degree. It certainly could get there because he killed the children. That's an aggravating factor, you know, killing a minor. But, you know, this is just a mess.
Right. Would they have had a viable defense? I mean, of course, in order to do that, you have to, again, admit that you killed them. I killed them, but I have a defense to that.
The creating a scene at her place of employment with a coworker, you know, kind of defeats the self-defense argument a little bit. It shows that, like, you were already kind of spoiling for this type of outcome.
Right, and these are all of the issues that we see that the defense attorney is really dealing with, because perhaps they did contemplate a self-defense or heat of passion argument that they would have argued right out of the gate. But they didn't go that route. They're more focused on the fact that there just simply isn't enough evidence to say that a murder was committed, and the murder was committed by Toledo. Now, of course, again, that tape, that interrogation tape, is very damaging.
You don't get around a confession. The juries, there are cases where there's no forensic evidence. The confession was obtained under such questionable, scenario and circumstances, but people just don't. Once you admit to murder on tape and it's played for someone, that's usually good enough for most people.
Right.
Because in most people's minds, why would you admit to killing someone if you didn't?
Right, and you get one or two more facts that might support that. You have the violent altercation. You have the middle of the night run to that parking lot. You have some blood. There's a lot of other issues or a lot of other factors that the jury could be considering that confession could really tip the scale. So only time will tell how the defense is going to handle this, and we anticipate that we'll be seeing that soon. We think the prosecution's probably going to rest today. We have some more witnesses coming up. We anticipate that court will be back in session at 1 o'clock. Until court is back in session, we're going to review this testimony of Kevin Dredden. Now, this is the victim's lover, describing that scene the day before the victim disappeared when Toledo came to the office and in that threatening manner. Here's the clip now.
Did you know Yesenia Suarez?
Did I know her? Yes.
Yes. And how long did you work with Ms. Suarez at American Canine?
I worked with her corporate-wise for, I guess, just over a year. Yeah.
What were her essential duties within the company as you understood them?
As I understood it, she was responsible for HR deliverables. She's the one that would be contacting the employee, doing their pre-hire documentation, and onboarding, scheduling the briefings with various departments, and then pass them over to operations, so the operation department can then make sure all the training is complete, and then move from there. So all the way up to the hiring as well.
And how did that dovetail with your assignment at American Canine? Tell us kind of how that transition went as an employee moved through to your area.
Yeah, I was a deployment manager, so I was responsible for identifying a manning shortfall or projection and working with Yesenia on telling her that, hey, I need a guy or a handler or a person, a kennel master for this contract. She would then work with recruiting. Recruiting would give her the name of the person, and then she would make contact, do their orientation, send out the employee agreements, and make sure all that's done prior to them flying to training. So I would work with her in relation to getting the making contact and saying we need to backfill a position, or...
Was she essentially your direct contact or a conduit through which you acquired new assets for deployment overseas or into the line of duty?
Correct.
Okay. How much contact do you believe that you had with her while on the job during the period that you worked together?
Well, it was a daily thing where we always would communicate. I think very seldomly would we not communicate.
Okay. And I just want to be clear that in 2013 you were working in the Lake Mary office, is that correct?
Yes.
Okay. Did you have personal contact as well as electronic or telephonic communication?
Yes.
How much time did you spend with Yesenia Suarez in a social capacity, away from work, Christmas parties, that kind of thing?
Yeah, well, we had the first one would be the Christmas party. And I had just, it wasn't much of interaction, but it was at the Christmas party. And then afterwards, we all went out to dinner. Well, not all, but some people went out to dinner.
Did you have an opportunity to meet her family, or more specifically her husband, Luis Toledo, during these social interactions?
Yeah, the first time I met him was at the Christmas party.
Okay. And do you see him here in the courtroom today?
I do.
Could you point him out, tell us who he's wearing, please?
Yeah, the man in a black suit, glasses.
Okay. And how much time do you think you spent with Mr. Toledo at the company Christmas party?
Not much.
Speak up, please.
I'm sorry. Not much.
Would you say in the time that you got to spend with him that you developed any sort of relationship at all?
No.
Okay. He wasn't a friend?
No.
When was the next time that you saw him? After the company Christmas party?
After the Christmas party, a few of us went out to eat. And then that was it. We all went home. The next time after that was we actually went out to Orlando. I forget the name of the place we went to, around Universal.
This was a separate night out?
This was a separate
dinner?
That's correct.
When you went out on this night to Orlando, how many people were involved? Was it just you and him?
No.
Okay, how many people went?
Okay, well, first, Yesenia, Lewis, myself, my wife, we went out to eat. And then we went downtown to Universal Orlando. And then we were met by a coworker, Mario, and his, I believe, fiance at the time.
Okay. During the second contact with the defendant, do you believe that you created any substantial relationship? Would you count him as a friend?
No.
Okay. When was the next time that you saw Luis Toledo?
I can't figure out that specific time, but it was in passing at the office or outside the office. When maybe I was outside and maybe he was, going upstairs.
Did you have any long conversation with him?
No.
Did you have any embrace with him? Hey, buddy, how are you?
No. Yes, I think we spoke.
Just you didn't hug him?
No embrace.
Were you that kind of friends?
No, we weren't that kind of friends. I mean, I don't believe, I think it's a thing there where I'm saying he wasn't my friend. I think everybody's a friend, so to speak. But we weren't friends.
Okay. So aside from these 3 times, when was the next time that you saw him?
The next time I would have saw him would be...
Toledo has reconvened. They're back from the break, so we're going live to the courtroom now.
Okay, what am I reading?
This is a police interview between Tyshawn Jackson and the investigators Fred Beers and John Maxwell on the evening of December 23rd, 2013, excerpt of that recorded interview.
There's some sound that goes with this?
No, I'll just read, it'll be faster.
About 7 minutes.
So we're live in the courtroom in the Toledo case. It looks like the judge is reading a transcript or waiting for the jury to come into the box. We do see Toledo there at the table. We still have Ken Belkin here, LawNewz trial analyst. We've been really breaking down some of this testimony that we've seen so far. We anticipate that the prosecution is probably going to rest today, and then the defense will start their case. Ken, what do you see the defense doing in this case? So there's a couple of strategic paths that you can take. You can not, you don't have to do anything as a defense attorney, correct? You can say,
yeah, I hate
fulfill.
when defense attorneys do that. I don't think it's effective. The only criminal trial I lost was a case where we did not put any witnesses on, and we just relied on our cross-examination of their witnesses. I think juries naturally want a narrative. They want a story. They want something that they can believe and hold on to. And by not putting a story on for them, I think you really do yourself a disservice.
Yeah, there is something to be said that even though the court would read an instruction and would advise the jury that the defense does not have to put on a case, and that if they do not, the jury can't hold that against them, there is something just in human nature that would say, well, why not? Why aren't you doing anything? Do you not have anything to say? Is there nothing that supports your case?
And by the way, human nature and just body language, look at these defense attorneys. They are not even acknowledging their client's existence right now. That's not good for juries to see.
And juries pay attention to all of that.
Juries pay attention. He should not be sitting in a chair by himself, removed from everyone. That defense attorney shouldn't be, cavorting it up with the prosecution right there. They should be sitting, well now, they're back sitting down. But, they should be there and, try to humanize their client a little bit for the jury.
Well, that is one thing that really is true, and that a lot of times people don't understand the impact of that. But when you're veteran trial lawyers, you know that all of that matters. The jury is really watching your interactions with the other side. They're watching your interactions with your clients. They're watching any family members or people that are there to support one side or the other side. And that oftentimes goes into their decisions.
I mean,
when
these
they're
attorneys
deliberating.
Look like they can't wait to be done with this case. They're trying to sit as far away from him as possible. He's trying to talk to him. He's not even looking at him. I don't know. I don't know what they're so busy doing.
Right. We don't know. No, we don't know exactly what's going on here. Still waiting for the jury to come into the courtroom. It looks like there had been, the judge was reading a transcript when they first came into the room, perhaps reviewing some of the testimony. We believe that court will be back in session shortly. It appears that there's going to be, maybe there's an evidentiary issue or an argument or something of the like that is coming. It looks like the judge is actually talking to the defense and the prosecution.
Okay, what's the issue? I don't know what the issue is.
Because essentially our issue is multi-faceted. The questions that would be asked to introduce in the recording, and the recording itself would be essentially what the defense is proposing is issues as far as the legal perspective. They're going to call high contract for the simple purpose of the things that are contained in the recording are things that you've already testified to under testified consistent with the recording. So it will be offered for a prior inconsistent. And they would be calling him to impeachment
not through his own testimony, but through the subjective beliefs of the officer, his credibility, whether or not he's lying. Assuming the testimony, it would not be admissible if the officers were called to the stand. There would not be a comment on whether or not they thought the witness was truthful. And so what I'm worried about is that through the playing of this hearsay recording, the officer's statement about their subjective belief of whether or not he's being truthful is all that is really being offered.
Well, let me dispense with something you said. People are allowed to call witnesses and impeach their own witnesses.
But not for the sole purpose.
Okay, then you're saying they're putting him up as a straw man.
Yes, I mean, they've already talked to Tom Jackson on direct and confirmed all of the things that he says in his statement.
Well,
If they've done that, there's no purpose in calling the witness.
well, I haven't heard a single thing other than this statement. And I'm not really sure what they're going to do. So I can't very well say, well, don't use the statement because I don't know what their purpose is. I'll have to hear the questions to see what exactly they're intending to do.
I understand, and I know the objection is a little premature because of that. And what I wanted to do is cut off any questions to introduce the statement about Mr. Jackson's law enforcement officer. I thought you were lying. That's the opinion of the officer coming into the question of the attorney. And that's improper question, it's improper impeachment. If you're saying evidence, it's all sorts of problems with those questions. And then there are additional problems with the rest of the recording itself.
Okay, well, I guess I'll have to just wait and hear because I...
He didn't tell you. He didn't tell you. He made a decision to go through something recently that he did not go through.
Well, I'll just have to wait and hear what you're going to ask him and what he's going.
Go ahead. Use the proper now. We have two officers that we're waiting on. We intend to call them to ask them about this case and their impressions of what Mr. Jackson was doing at the time and whether or not they can review it. I don't see that being anything that could be done with Toledo and the person on the officers that live in the state. They're allowed to live their impression as their state of mind at the time. All that we're allowed to ask them is to count what he's saying. I think that's the question.
That's one thing, to challenge the statement. It's quite another to say, well, did you believe him? Okay, all right, well... I'll have to wait. You're asking me to rule on something that I don't know anything about. I mean,
It's fine, though. The thing I wanted to talk about primarily was the questions and
well, I mean, there are methods of impeachment, and I'm assuming they will follow the rules when it comes down to impeachment. So.
We've asked that have that on drive. We've asked that
ID only. Okay. Okay. All right. Oh, what about the one that's ready to go? Okay, and is that just the only two other witnesses you will have for today? Today? Okay, then I guess we'll be in recess until 1:30. In here? Okay, all right, we'll take a 10-minute recess. Sure, okay, 15. Go ahead.
We were briefly back in the courtroom on Toledo when the defense and prosecution tried to work out some issues with the witnesses that the defense anticipates calling in the case. Of course, the first is, we know, and we heard this a few days ago, the defense intends to call Tyshawn Jackson, of course, who already testified for the prosecution. Now the defense intends to call him for their case. Another issue that was addressed here in that meeting before the judge, the defense and prosecution arguing about calling two police officers where the defense intends to ask them about their impressions of Jackson's story. The prosecution was objecting. We were having a little bit of trouble understanding what the lawyers were saying, but we did hear the judge say that he needs to know a little bit more about what the questions are and what actually is going to be discussed during that testimony from these two police officers. I'm sure we can surmise if the defense wants to call these two police officers with respect to their impressions of Jackson's story, that it's probably going to be something positive for the defense, but only time will tell. Another interesting fact, we learned that the prosecution intends to rest today. Two more witnesses on tap, and court will reconvene at 1:30, and then the defense will pick up with their case from there. We're still here with Ken Belkin. He's the LawNewz trial analyst. Ken, so we just watched this interaction between the defense and the prosecution, obviously working out some issues with witnesses, very typical. But what's a little bit atypical is the fact that the defense wants to bring Tyshawn Jackson back on the stand and have him testify on their behalf. So what do you think this means? What do you anticipate seeing?
Brilliant move on the defense's part. Absolutely brilliant. This is like the O.J. Simpson, Mark Furman gamble. They're going to get him on the stand, and he's going to have to take his Fifth Amendment right against self-incrimination. At some level, he's going to have to do so.
Yeah, do you think he's probably going to come with a lawyer? I mean, I would imagine under these circumstances, he's going to have someone there to protect his interests.
This is going to be fun to watch. They're going to be permitted to treat him as a hostile witness. You know, it's going to be pretty riveting. It's probably going to be the most riveting thing we're going to see in this trial.
I actually am looking forward to that. It should be interesting to see what else comes out. But can you take us through, so from a legal perspective, as a trial lawyer, you get to cross-examine a witness. So you already have the opportunity to get whatever you need on the record as far as testimony.
Yeah.
Why call the witness back?
Well, cross-examination, you know, first off, you're only permitted to ask things that are within the scope of the direct examination. So by calling him on direct, they're going to be permitted to ask him things that were beyond the scope of the initial cross-examination. Now, that's going to be good. It's also going to be bad for Mr. Jackson because he's going to have to plead the Fifth. If he did act as an accessory after the fact, he cannot incriminate himself on the stand. I'm sure he has counsel that has advised him as such, and it's going to be fun to watch him squirm.
Very interesting. Well, we do know that there's this other issue here about the impressions about Jackson's story that they intend to call two police officers. What do we think is going to happen there? What do you think this is?
With the prosecution calling two police officers?
The defense intending to call two police officers regarding the impressions of Jackson's story. I mean, we don't really know what that means yet. There was argument of some sort of statement that came out. We don't know exactly what that is at this point. But
well, look, presumably the prosecutors have complied with the Brady requirements, which means there's a Supreme Court case, Brady, that says prosecutors have a duty. If they uncover exculpatory evidence, meaning evidence that is likely to, that is indicative of the fact that the defendant may not be guilty, they have to turn that over to the defense. And they have to make a record that it's considered what they call Brady material. So presumably, they might be calling these two police officers because things in their notes, maybe things in interviews with Tyshawn Jackson, were indicative of the fact that they thought he was lying.
And that perhaps could be what we're looking for. I mean, obviously, when you're talking about their impressions of his story, that would lead us to believe the defense wouldn't put them on the stand if they didn't think it was going to be favorable.
Number one thing he's probably lying about is, oh, you didn't ask why at 2 in the morning you were going on this makeshift car wash adventure? You know, come on. Someone asked you to clean blood out of their car at 2 a.m., most people would be like, what?
Right. Absolutely. I mean, certainly that part of the story is a little bit strange.
I mean, we already know if I call you at 2 a.m. to help me clean some blood out of my car, we already know you're going to have some questions.
I've already declined. I've respectfully declined.
Not even accept, but with questions?
Yeah, no, I think I'm just going to outright decline. Sorry, Ken. I'm sure there's some other folks here at the LawNewz Network that would be happy to help you out.
Let's see if Deborah Blum's available.
Yeah, we'll see if she's available. She'll probably, maybe she's no questions asked. I don't know. I can't speak for her, but we'll see.
She's more likely to be the murderer than me.
That's just a side note. So now we know that the prosecution is going to rest today. We know the defense is going to be putting on at least these two witnesses, the police officers, about these impressions. Again, what do you think the defense is going to do to try and rehabilitate their case?
Look, I think the defense at this point is going for just trying to remove Mr. Toledo from having any culpability for the murder of the children. I think that's the strategy right now. They really can't get around the fact that he killed his significant other. They really can't. He confessed that. No jury is going to fail to believe that he killed her. The two kids, I think there's a lot less evidence tying him, and he's got a good shot at not being convicted of those two murders.
Right, there's at least something there.
A shot.
He's got something there.
And when I say a good shot, I mean like,
right.
Not much.
There's something there for them to hang their hat on, and that there just hasn't been much evidence connecting him to those. Yeah. Of course, the finger pointing at Tyshawn Jackson, perhaps that will come out in this testimony with the other two police officers that we know we'll see when the defense puts on their case later today. It certainly will be interesting to see where the defense goes there. We know the prosecution is going to rest today. That's what we heard in that meeting. But in order to move forward in this case from a defense perspective, we know that the defense is going to have some witnesses and all of that. What do you think they're going to do in their closing? How are they going to address this confession? Because you cannot, we all know as lawyers, there's a golden rule. Don't leave out the bad facts. Hit the bad facts head on and talk about why they don't apply in your case or whatever would mitigate that factor. In this case, you've got that confession tape. You certainly have a problem during that interrogation video. You've got a couple of different stories floating around, and then ultimately you have him admitting to killing the victim here. So what do you think they're going to do? How are they going to rehabilitate that in the context of a closing?
This is tough because on one hand, in order to get your credibility back, it's almost like you have to concede that he killed the woman. In order to get any credibility to the proposition that he didn't kill the children, you sort of have to concede that he killed her in a jealous rage. Unfortunately, this is a tough position for a defense attorney to be in because you don't want to concede on a murder charge. On a murder count, it's just not good.
Right.
But this is going to be tough. My personal feeling is they're probably going to get him on all three counts, even though I don't know that there is evidence beyond a reasonable doubt for the murder of the two children.
Right. But it seems it's hard to get out of the murder of the two children if you believe that he committed the murder of his wife, unless they can point to that alternate theory, and that raises enough doubt.
Yeah, because by the way, Tyshawn's just some guy that you knock on his window at 2 a.m. to hey, I need you to help me with the cleaning up and kill the witnesses while you're at it. It's a little bit laughable,
Yeah, the story certainly.
And Tyshawn's just
holes.
okay, let's clean your car. I'll kill the witnesses, sure, no problem.
Right. We're not really sure how that's helpful.
It makes a lot more sense that Toledo killed her in a jealous rage, and then in a moment of distorted clarity realized there were witnesses. And in his warped thinking, he had to get rid of the witnesses.
And you're probably going to see something like that coming from the prosecution in their closing,
which
pointing
is weird for me to be saying.
Right, but Ken, you got to wear both hats.
Yeah,
you're flipping
absolutely.
both sides of the coin, so we know that there's certainly going to be a lot of that being hammered home by the prosecution. The prosecution's really going to go after some of these critical facts that we've been talking about today. And we're waiting now for the prosecution to close their case, which they said they will be finishing up today. We anticipate that they'll rest. We know court will be back in session in about 10 minutes now. The judge put the court on recess until 1:30. In the meantime, while we're talking about Tyshawn Jackson and the potential for that to be an alternative theory for the defense and how the defense is going to use that in their closing, we'll review some of his testimony now.
Develop a relationship with Mr. Toledo and the children who live next door.
This is like around the summer of 2013 when I started going to barbering school.
He went to barber school too, right?
Yes, sir.
Did he go to barber school before you did?
Yes, he did.
Was that a large part of the reason that you went to barber school?
Yes, sir.
Before you started going to barber school, had you ever spent any time with that man?
No, sir.
How long had you lived in your home at that point?
I want to say like at least 6 or 7 years.
And how long had he lived there, next door?
At least like 2 or 3 years already.
Okay. Did you ever talk to him?
Not really.
Describe your relationship prior to barber school.
Just like hi, bye, and pretty much that's it. Just saying hi to him.
Were you the kind of neighbor that would wave when you go to the mailbox?
Yeah. Not all the time. I'll say hi when somebody like says it to me.
Anything more sophisticated or more entailed than just hi and bye and waving occasionally?
No, sir.
Would you call him a friend at that point?
Not at that moment.
What did you do after school, typically? What were some of the things that you did?
If I didn't have to go to work, I would like record music.
What kind of music?
Mostly hip hop.
Do you have a mixing studio in your house that you use for friends?
Yes, sir.
Do you have a girlfriend?
Yes, sir.
How long had you been together with your girlfriend?
Probably about a month prior.
What was her name?
Courtney.
You still with Courtney?
Yes, sir.
She's the mother of your children?
Yes, sir.
Now, at this point in your life, you had gotten into a little bit of trouble, right?
Yes.
Okay, why don't you tell us about that?
I'll say probably a month prior, I had the police come to my house. They came and did a search warrant of my house and found marijuana at my house.
Did you get convicted at some point of a burglary as well?
Yes, sir.
Okay, tell us about the burglary, please.
It was probably almost the summer of 2012. I was in my senior year. Pretty much prom was coming up, and my mom was working pretty hard, and I didn't want to ask her for like money for prom and stuff, so I took it upon myself to go figure out a way to get it. So I was stupid and young pretty much, and tried to figure out a way to get it without asking my mom and burglarized the school.
What'd you do?
We were trying to take some computers.
Do you regret doing that?
Yes, sir.
Has it made it difficult to find work in your life since then?
Yeah, pretty hard, honestly.
In October of 2013, were you still on probation for this offense?
Yes, sir.
Do you remember your cell phone in October of 2013? What number it was?
I don't remember the number by heart.
If I read you a number, do you think you'd recognize it?
Yeah.
386-960-3604?
Yes.
Was that your number?
Yes.
Was your mom's telephone number 407-272-3105?
Yes.
Now, you've already told us that the defendant lived next door.
Yes, sir.
You see him here in the courtroom today?
Yes.
Could you point him out, tell us what he's wearing, please?
He's wearing black with glasses and a jacket.
Was he married at the time that he lived next door?
Yes, sir.
Did his wife have children?
Yes, sir.
How old were the kids?
Like around 6 or 7.
Was there a large age gap between you and the defendant?
Yes.
Was his life very different than yours?
Yes.
Was it enrolling in barber college that really allowed you to get to know the defendant?
Yes, sir.
Tell us how you came to know him over that time.
Pretty much he'd take me to school every day, and we had classes together, so we got to talk more.
Did you have a car at that time?
Me? No.
So really, he was your way to improve your life?
Yes, sir.
Did you spend time together in your classes? I know you said you had classes together.
Yes, sir.
Did you study together?
Yes, sir.
Do you know the name Robin Roberts?
Yes.
How do you know Robin Roberts?
From school.
Was she also a good friend and confidant to you?
Yes.
When school would end in the afternoon, go straight home?
Yes, most of the time.
Did you end up spending some time at his house?
Yes.
Tell us some of the things that you would do with him.
Pretty much just play video games.
Were the children there?
Yes.
What'd you do with the children?
Sometimes I play basketball with the kids or help them with homework, help Toledo like do backflips and stuff for her because she wanted to learn how to do backflips for cheerleading. And pretty much that's pretty much about it.
Did you like the kids?
Yeah. They're nice kids.
Did you feel close to them?
Yes.
Did you have anything to do with their death?
No.
Keep going.
Did you ever spend time with the defendant's wife, Jasenia?
No.
Did you have anything to do with her death?
No.
What time did Jasenia usually come home from school in the afternoons?
No.
You need a second? Has this been difficult for you, Mr. Jackson?
Overall.
Yes.
Did you ultimately learn that the defendant blamed the death of his children on you?
Yes, sir.
I mean, you weren't even there, were you?
No, sir.
I want to go back to Jasenia for just a minute. She was a busy woman, wasn't she?
Yes, sir.
Did you know she was going to school and working at the same time?
Yes.
When she came home in the evenings, did you hang out a whole lot longer?
No, sir.
Why not?
Usually kind of indicated it was family time for me, and like pretty much it's time for me to go.
Did you ever see Jasenia upset with her husband?
At times.
What was she typically upset about?
Just like normal stuff around the house, like laundry, kids' homework, just normal stuff.
Was it arguments? Was it fist fights?
No, I didn't see any fist fights, but I know there's arguments.
Did she have really high standards?
Yes.
I'm sorry. Sustain, can you rephrase the question?
Sure. Did she want her kids' grades to be perfect?
Pretty much, yes. She expected the high of them, yes.
Okay. Did she want the house to be very clean?
Yes, she's very cleanly.
Did she want laundry folded and dinner cooked?
Yes, from what I've seen.
Did the defendant ever talk to you about his marital problems or arguments that he'd have with his wife?
Occasionally. We never got too deep into it.
Was it clear to you that he didn't feel appreciated for the things he did around the home?
A little bit. He complained about it.
Did you become aware at some point that they were going to have a divorce or that they were getting divorced?
Yes, towards the end. Last couple of days in school, I seen him. He spoke about it.
Was school ending in October? You say it was towards the end of the school.
Before he stopped going, before all this trial stuff happened.
In October of 2013, did the defendant change fields from barber to HVAC air conditioning?
Yes, sir.
Did he ever tell you why he did that?
Pretty much because of money and more stable. Like, it feels a little more stable.
Could he still attend the same school and attend the HVAC classes or the air conditioning classes?
Yes, it's the same school.
Did you continue to ride with him during that period of time?
No, our schedule was conflicted. It's different scheduling.
How far in advance of these murders on October 23rd, 2013, did the defendant... Before October 23rd of 13, did you know that Jasenia Suarez had gone on a business trip?
Yes, I heard of it.
Okay. Did you know the length, the duration of the trip and where she had gone?
Yes, I believe he told me a week.
Is it possible that it was only Sunday to Wednesday?
Yes, it's possible. I don't really remember exactly.
Did you know that she had gone to Alabama? Did you know any of the details?
Yeah.
Sustained.
Did you know any of the details of the trip?
Yes, he told me a few things about it, that she's going to Alabama for a trip, for a business trip.
When was the first time with respect to her return that you heard about the defendant getting a divorce?
I don't exactly remember. I want to say like a Monday or something, or maybe the same day she got back or the next day. It's a long time ago, I don't remember exactly, but I know it was during school. He came to me. Sorry. After she got back during school, he came to me and told me about, I guess, a few problems they were having. I didn't go too far into detail with him.
Why didn't you go into detail with him?
Pretty much it's like it wasn't really my business. Like it's a little awkward talking about a guy getting divorced to his wife. I kind of want to stay out of it.
After that point where you had that conversation with the defendant, did his behavior change?
A little bit. I didn't really see him as much, so I can't really say I hung around too much to tell like how much his behavior changed. But he didn't seem like the want to help everybody out type of semi he usually is, you know.
And you just referred to him as Semi, is that correct?
Yes, sir.
Was that the nickname that you called him?
Yes, sir.
Did you ever hear the defendant telling someone at school that he was checking Jasenia's phone records?
Yes, I heard of it.
Did the defendant also say that he had copies of her records to see if she was cheating?
Yes, I heard something of that too.
Yes, sir.
Turn your attention back to October 22nd, 2013, I believe, just before the break. You told us that you had gone to school that day and got home around 2 o'clock.
Yeah, yes, sir.
Is that accurate?
Yes, around that time, I believe.
Do you know the name Traquan Williams?
Yes, sir.
Okay. Back in 2013, was his phone number 386-307-4694?
I don't know about how it could have been.
Okay.
I believe so.
Was he a person that you called frequently?
Yes.
Was he entered in the memory of your cellular telephone?
Yes, sir. I believe so.
If that was the number listed, do you have any reason to dispute that?
No.
Did Mr. Williams come over to your home that afternoon?
Yes.
For what purpose?
He had a song that he wanted to record.
And how long did he stay at your home?
Probably like 4 or 5 hours. I don't remember.
After he left, what did you do that evening?
I don't really remember too much. I know I called my girlfriend, talked to her for a while before going to sleep.
Did you go anywhere?
No, I know I didn't leave the house.
You stayed home that night?
Yes, sir.
Who cooked dinner?
My mom.
You remember what she cooked?
I believe it's spaghetti or something.
In addition to calling your girlfriend, I think you said you called her. Did you also have text messages back and forth with your girlfriend?
I'm pretty sure we text every day.
What time did you go to bed that night? Do you remember?
Probably like around 11:30, if I remember correctly.
Was that your typical practice?
I guess I don't really have like a typical practice. Sometime around that time.
Just go to bed when you get tired?
Yeah, pretty much.
Now, you have an odd nighttime ritual.
Yes.
Why don't you tell us about it?
I wake up and I snack a lot in the middle of the night.
Are you the only person in your house that does that?
No.
Who else does that?
My mom.
Your dad also do that?
Yes, but he doesn't live with me, but he does.
What time did you typically wake up?
I don't really know the times. It's just like random times, just wake up in the middle of the night, just go grab like a bowl of cereal or something.
You'd eat a bowl of cereal in the middle of the night?
Yeah.
Was that a fairly common occurrence for you?
Yeah, pretty much.
Was it a fairly common occurrence for your mom?
Yeah.
Did you often run into her in the kitchen?
Sometimes, not really. It was kind of weird running into her whenever I did, but yeah.
Did you do anything else while you were up during these nighttime hours usually?
I called Courtney.
And how did she feel about that?
She wasn't the happiest, but she answered.
What did you talk about with Courtney when you call her?
I don't really remember. I usually just call her as like, I don't know why. I usually just call her in the middle of the night when I wake up or something. I don't know. We don't really talk about much. She just say I'm sleeping. It makes me and tell me to hang up the phone.
Do you remember calling her on this particular night?
I don't remember it. Like it's been so long ago, but I know I called her, but I just don't really remember it.
Do you know how long the call lasted?
No.
If I told you it lasted 26 seconds, would that seem odd to you?
Sustain.
No.
Sustain.
Aside from getting up and eating that evening, what else did you do that night?
Nothing I can remember.
Did you stay in bed?
Yeah, I went to sleep.
Now, you've got a dog in your house, right?
Yes, sir.
What's the name of the dog?
Mr. Biggs.
Okay, and where does Mr. Biggs sleep?
Sleep in my mom's room.
Always?
Yeah, on her couch. She has a couch in there.
Did you ever let out Mr. Biggs at night?
No.
Why not?
Because he was in my mom's room, and I really don't let him out at night.
How big is Mr. Biggs?
He's a Chihuahua.
Did you ever leave your house on the night of October 22nd, 2013 into the morning of October 23rd, 2013?
No, sir.
Did you ever see the defendant during the nighttime hours?
No, sir.
Did you hear any noises coming from his house?
No, sir.
That changed around 6:11, though, right?
Yes, sir.
What happened at 6:11?
Yes, sir.
May it please court?
Court is pleased.
Mr. Jackson, when did you see the defendant?
I believe 6:11 in the morning.
Okay. And tell us how that interaction occurred.
I was laying in my bed and I heard a tap on my window.
Were you awake?
No, I was not awake. I was awakened from the tap.
Tell us more.
It was pretty early, so like I was wondering like who it was. I looked up. I have a Time Warner box. Like I had a box in my room for Time Warner or Bright House, and it's had the Time Warners. And it said 6:11. Like who would be knocking at my window at 6:11 in the morning? And I opened my window and I looked and I seen Toledo.
Okay, and where was he?
He was at my window.
Was that in front of your house?
Yes.
Okay. What was he doing?
He was standing there motioning me to come outside.
And what happened next?
I walked to the front door and opened my front door, and he was standing at my front door.
How was he dressed?
He was dressed in black, like a black shirt, some black sweatpants, and some boots.
What did he want?
He asked me for a favor to help him take his wife's car somewhere. He didn't exactly say where. He just asked to help him take his wife's car somewhere.
And what did you do?
I put my slides on that was by my front door and went next door.
What are your slides?
Excuse me?
What are slides?
Oh, like flip-flops, but without the thong thingy in the middle.
And what were you wearing at that time?
Gym shorts and a tank top.
Did you change your clothes when you got up?
No.
Is that what you had worn to bed?
Yes, most likely. That's pretty much my entire...
Did you take your phone over to the defendant's house when you left?
No, sir.
Why not?
I just have it in my possession right then. I thought it was going to be like we go here real quick and come back home type of situation. I was just trying to get back in bed before I had to go to school.
What time did you have to go to school that morning?
I usually go to get to school, like, I think like 8:30 or something like that.
When you went over to the defendant's house, where did you go specifically?
We walked into the driveway.
Tell us what occurred when you got in the driveway.
When we got inside the driveway, the garage is already up. And then he told me to wait there for a moment. He walked inside the house and came back out and handed me the keys.
While you were waiting, where did you wait?
I wait on the hood of the Saturn.
As you sat on, did you sit on the hood of the Saturn?
Yes, sir.
As you sat on the hood of the Saturn, did you notice whether the hood was warm or not?
I didn't notice any warmth coming from the hood I can remember.
While you were sitting on the hood, where did the defendant go?
He went inside the house.
How long was he in there?
It could have been like longer than 10 minutes. I don't really remember.
When he came back out, was he still dressed the same?
Yes, sir.
Did it appear to you in any way that he had changed his clothes?
No.
What occurred when he came out of the house?
He handed me the car keys and asked me to follow him.
Did you notice whether his wife's phone, the black Honda Accord, was there?
Yes, the Honda Accord was there.
Where was it parked?
It was parked in the garage.
How?
Front end, forward, facing the house, like just regular drove in. He didn't back it in or anything like that.
So it was nose in into the garage?
Yes.
Did you notice whether any of the doors or the trunk were ajar?
I seen the trunk was open.
Did you make any observations about the trunk or what was in it?
It seemed a little dirty to me.
In what way?
Like it was dirt on there.
There was dirt on it?
Yes, sir.
Not dirty like messy, there was a lot of stuff in it?
Like not a lot of stuff in it, like just actual dirt, like dirt. Not messy, just dirt.
Did you make any observations about the defendant's clothes or his shoes?
I noticed his shoes were kind of like had dirt on.
We're back in the Toledo courtroom live now.
I think the jury would have to hear from him first. I'm sorry? Mr. Jackson. I think he would have to come in and either own up to the statement or reject the statement and say, no, I didn't do it. If he rejects it, then this is academic. The whole thing comes in. If he admits to it and you cross-examine him on it, I think, well, I would just have to see what he says. I don't know what he's going to say. Is there a reason why you want to put that in first? Because it's anticipatory impeachment, which I'm not aware of. But that's the whole thing. I don't remember him saying it.
He didn't say it.
Well, if he didn't say it, how can he be impeached?
Because that's not all he said. He would ask certain questions of him, and he answered the question. The full story wasn't presented. And so if I call an officer on Elk Place, and I say, "Did Mr. Jackson tell you what Mr. Toledo was wearing?" And he says, an officer can say yes. And if you find that in the dumpster, yes. If you tell him that story didn't add up, and he says yes, why can't I do that even if I don't put it? That's all it takes. I don't see how that's any different than saying we had stuffed animals.
Well, the difference is this: Mr. Jackson never was pointed out that he might have said an inconsistency. That hasn't been an issue in front of the jury, as far as I can remember in the evidence. And I'll have to go back and look at my notes. But I don't recall him saying, you know, black shirt, black pants, black boots. That's what he was wearing. And that's it. That's his testimony. Nobody ever said, well, how can he be wearing all those things? Those things are found in the dumpster. That issue has, but I think you have to ask him first. I think you would have to ask him first in order to bring the issue up.
Well, if he was asked, and that meant the answer he gave before wasn't this answer. I think you asked why we have to bring him in and say.
He was never asked. That's what I'm trying to say.
We want to control what we're doing.
Okay. I think this is a straw man argument.
So we just heard an argument between the defense and prosecution, again regarding calling Tyshawn Jackson to the stand. Again, the defense intends to call him as a witness for their case. Apparently, there is some question about a discrepancy in the clothing description as to what Toledo was wearing that night. Now, we just heard the judge say, I believe this is a straw man argument. That means that the question has not already been asked. So the judge is saying that in order to impeach Tyshawn with respect to his testimony that he previously made during the prosecution's case, that question would have to be asked of Tyshawn Jackson on the stand during this second time around. The prosecution was talking about impeaching Tyshawn Jackson, and the prosecution was objecting, saying they're planning to improperly impeach him. The judge saying, well, some of these questions haven't been asked, so how are you going to impeach someone's testimony over something that they were never asked? So I'm still here with Kent Belkin. We're here in the studio. It looks like the court is actually on recess. Again, the Toledo was just dismissed. We just saw them walking out of the courtroom. A big confrontation regarding Tyshawn Jackson and his testimony that we anticipate the defense is going to call him as a witness for their case. We do think that the scope of that testimony will likely be outside of what we heard during the prosecution's case. Of course, the defense trying to go after this issue with the children, what Tyshawn Jackson's role might have been. We will see him as a witness. It appears from these pre-jury discussions where the court was listening to arguments between the prosecution and the defense while the jury wasn't in the room. I'm still here with Ken Belkin, trial news analyst. Now, Ken, let's see what we're talking about here. We're talking about Tyshawn coming back on the stand and there being some questions that have not already been asked in the prosecution's case that the defense intends to ask. What's the rule there? Is there any limitation outside of just what is relevant that the defense can ask based on Tyshawn's previous testimony?
It's really got to be relevant. But look, when Tyshawn was called as a prosecution witness, prosecution got him to do direct testimony. Defense had the opportunity to cross-examine him. But the cross-examination had to be within the scope of what was asked and what was spoken to and testified to during the direct examination. Now, as they call him as a defense witness for direct questioning, they can go beyond that scope. It seems to me they're going to make some hay over a misidentification of a clothing item that Mr. Toledo was wearing. I don't really know how effective that's going to be. I don't think it's really in dispute at this point that Tyshawn was with him. I mean, Toledo says he was there, that he killed the kids, and Tyshawn says he was there, that he helped Toledo on this very early morning car wash expedition.
Right, at the 6:10 a.m., just to clarify, that was the time that Tyshawn Jackson allegedly went with the defendant to go on this car wash expedition, as you said, and the wrap upon the window and all of that. It appears that what the defense was asking is that they want to put the police on the stand about Jackson's statements before Jackson takes the stand again. So there are some statements out there. Earlier today, we saw another argument between the prosecution and the defense with respect to these statements. The judge had seemed to say that they were going to be permitted to put Tyshawn back on the stand and that he would be assessing whether or not, or what was appropriate at that time, that he had to be on the stand and he had to know what the questions were going to be in order to really address it. Everybody stepped out of the courtroom now. Apparently, they want to secure the area so they can all talk through this issue and maybe get in a little bit into what's in those statements and what is going to be asked of these police officers. Obviously, the defense has a strategy and a plan here that seems to be revolving around Jackson, because now we know Jackson's going to be back on the stand at some point. We also know that there's these statements and the testimony of some police officers, and what we heard today, impressions. So impressions of what Jackson's story was by these police officers. So what does that all mean to you as far as where the defense is going here? I'm seeing a little bit of accountability put on Tyshawn Jackson in a stronger way than we've seen before.
Yeah, they're trying to shift the blame here. But look, in the final analysis, I'm sure there were notes turned over, tidbits from the interviews the police conducted with Tyshawn that indicated the police thought he was lying about things, that they thought he was less than credible. And they're going to try and bring that into evidence and have the jury consider the fact that at the time of the arrest or shortly thereafter, these police didn't find Tyshawn to be the most credible person.
Right, absolutely. And we know that, and we know that there were some issues, and there may be even more issues in this statement that we anticipate that we'll see. Now, Ken, we heard the judge say, and I want to quote him exactly, if you're going to put up a straw man, you are going to have to put him up first to see if I'm going to let you knock him down. Now, the judge is referring to a straw man argument, which is really a legal fallacy. They were arguing about impeaching Tyshawn Jackson's testimony, and the judge was a little confused. He's like, well, I think the subject matter of the clothing actually didn't come up the first time around. So you can't impeach someone's testimony if they've never testified to that particular fact or that line of questioning wasn't asked. Can you explain that a little bit more to our viewers?
I don't think the defense attorneys are really being honest here. I don't think that's their intention with putting you up there. Really, we're going to dispute an article of clothing worn by Mr. Toledo this stage of the game? It's really not disputed that Tyshawn and Toledo had this little early morning rendezvous to clean his car of DNA evidence. Not disputed. The only thing that's really disputed is how far Tyshawn's involvement goes. Did he, in fact, take the lives of these two children, or was he merely just a guy with a squeegee?
Right, and we don't know yet, and we do know, again, for me, one of the biggest points in Tyshawn Jackson's testimony that I was not on board with was this: I just didn't even want to ask I didn't even ask a question about what I was doing there. 6:10 a.m., I get a knock on my window.
From a former Latin King gang member.
Well, Ken, let's talk about that.
As you brought up
yes,
during the break.
I know. Well, we were talking about this during the break, and I think this is an interesting point. A lot of our viewers are asking, what do we anticipate seeing in the defense case? Well, right now we know the defense case is going to be revolving very much around Tyshawn Jackson. We know about these two officers. We know about some statements. But the big glaring question that we have in every one of these trials, will we see that defendant take the stand? And in this case, I would say, no, probably not. And I'll base that solely on just that interrogation video where there were so many inconsistencies. You have to watch out putting your client on the stand, because that person can be impeached, and some information that may not ever come out to the jury could potentially come out if your client's on the stand. Now, Ken, we know that before trial commenced, the prosecution was trying to get a fact into evidence, and that's that Toledo at some point was a gang member, and a high-ranking gang member in the Latin Kings. The prosecution trying to get that in based on two arguments. One, a propensity of violence, makes sense there. Number two, that Tyshawn Jackson didn't question Toledo or wasn't able to call police after this incident because he was afraid of Toledo and he was following his directives given his stature as a Latin King. Now, that makes sense. We know that. The jury doesn't know that. That was precluded, found to be prejudicial and not probative. Is that something that could come out if they put Toledo on the stand?
High-ranking member in the Latin Kings, also known as the dream job my father wanted for me. But, you know, at the end of the day, your crazy neighbor who's a member of a murderous gang that everyone knows about, everyone's heard about, comes rapping on your window in the early morning to help you wash his car. It takes a very strong-willed person to say, nah, you know, I'm busy.
Right.
Tyshawn doesn't seem like that strong-willed person.
Well, this is now an interesting fact because obviously it's been deemed, the court said that was too prejudicial. We're not going to bring in the fact that he was a member of the Latin Kings.
Yeah.
So that kind of leaves a hole, though, right, for Tyshawn Jackson as to if you're asked to explain why. Well, the defense is not going to ask him that.
If the defense slips up and opens the door to this, you know, that's their own fault. Sometimes this happens in cases. The defense will fight very hard to keep a particular set of facts and issues out of the view of the jury, but you always run the risk if you ask a question and inadvertently that witness testifies to those facts or issues, you've opened the door to that and you have willingly invited that into the proceeding. And at that point, the judge is not going to, you know, sustain any objections to keep it out.
Right, Ken, you make such a good point, and that actually happens all the time. And it's not necessarily that a lawyer was even as sloppy or anything like that. It's just that sometimes the form of a question could be something unanticipated. A fact comes out, the prosecution has the argument that the door was open. It doesn't have to be so clear cut that you say, well, why didn't you call the police,
by the way,
or something like that?
They run a particularly high risk of that happening in this situation, because usually when you call a witness for direct testimony, you have spent considerable amounts of time, if you're doing your job as an attorney, to prepare them to testify to how you want them to answer the questions. Always truthfully, of course. You don't want to suborn perjury, but there are ways of answering questions that are more effective than others, that come across better. And they're not going to have the benefit of that preparation with this witness.
No, they're not going to, and it's going to be something that they certainly have to watch out for when you're talking about the scope of the questioning. Obviously, you see the defense strategy here is to go after Tyshawn in some way, or to get some facts on the record that would tend to undercut his story.
They better hope that this guy pleads the fifth. They better hope that he pleads the fifth. And I think that is what this is all about, is that they're hoping that they can get him early on with a series of questions where he pleads the fifth, and then that seriously undermines his credibility with the jury as a witness.
And it could be, that certainly could be. And just to explain that a little bit to our viewers, because there was some confusion, because Tyshawn Jackson had already been on the stand, he had already testified, he did not plead the fifth that first time around. The scope of the questions can be different the second time around because the defense is doing the direct examination. So it's going to be slightly different, a slightly different dynamic between the defense attorney and this witness, and there could be the potential that those questions could go outside of where they went before, putting Tyshawn Jackson in some dicey territory as to whether or not he could potentially incriminate himself. Now, there's another issue that could be prevalent. Now, we talked about this Latin King issue. Obviously, that's a great point, Ken. The defense has to really watch their questions because they don't want to open that door. You know, the prosecution was chomping at the bit to get that in. The fact that he's a gang member.
Look, this is a big gamble for the defense. But in a case where the stakes are this high and the odds are stacked that high against you, you've got no choice but to take risks like this. It's like high stakes poker in a way.
Right. So now we know where the defense is going. It's very clear what their strategy is, that we see all of these beginning witnesses that are going to begin their case revolve around Tyshawn Jackson, revolve around Tyshawn Jackson's story. Now, why are there any other reasons outside of this gang member, Latin King issue? Why else would a defense attorney not put their client on the stand? Because, to play devil's advocate, is there some value in putting Toledo on the stand to explain away some of the problems in this case?
Oh yeah, of course. And all the social science research indicates that juries and people in general, even if they are told by the court not to consider the fact that a defendant doesn't testify, not to hold that against them, all the research suggests that people still will hold it against them. Because in the final analysis, we feel, and it's common sense that we would feel this way, if someone does not explain why they're accused or say that they didn't do it, that they must be hiding something. Now, another reason you might want to not put Toledo on the stand, he, you know, not to be disrespectful, he kind of looks like someone that would kill a woman and her children. His demeanor, he looks like a mean guy. He's walking out of the courtroom. I know the defense attorneys, or maybe he did this, tried to soften him up by putting glasses on him. I think he's the only person that looks meaner with glasses on than probably off. And the way he walks, very cocky, very arrogant. He's just got a demeanor about him that you would expect from a high-ranking member of a gang.
Well, and that and all of that could potentially be an issue, as we said. The juries often look and look beyond what just the testimony is. They're paying attention to the interactions between the attorneys, the defendant, the prosecution, the witnesses, people in the courtroom. Certainly that's an issue. Now, what do you think about that ruling, Ken, to keep out his affiliation with the Latin Kings? Obviously a victory for the defense. A
big victory for the defense. Interesting that the court ruled that way. You know, I think there was an argument why it could have come in, you know, as you said, his propensity for violence. You know, the way he might have committed these murders might be similar to other criminal activities he's undertaken in furtherance of the gang activity. You know, there's a whole raft of issues there. But,
right.
You know, in the final analysis, this is not a gang-related killing.
Right. So at the end of the day, nothing points to that. This is more of a domestic issue. So you can see why the judge would lean towards, all right, if this had any affiliation to a gang killing or any allegation that this was something in the context of the gang or an ex-gang member or something like that, you would absolutely see that coming in. It's very common that gang affiliations are addressed in criminal trials if that is a part of the case.
By the way, this only comes in if he takes the stand and the prosecutors cross-examine him, or if the defense calls a prosecution witness on direct, as they're doing right now. Got it.
So what other factors are going through their mind? Is it just prior convictions that could come in if he was on the stand, or is it other bad acts that would generally be precluded?
They would have to ask for a pretrial ruling on it, but sometimes prior uncharged bad acts are admissible.
Which could potentially be out there.
Yeah, which could potentially, in his case, more than certainly they're out there.
Right, absolutely. So that's certainly a risk, and probably a risk that the defense is not willing to take. Another factor that would really go into the defense theory on whether or not this would be something strategically that would help the case is just Toledo in that interrogation video. Ken, do you think that they're thinking about that he told some inconsistent stories in that video? So now he goes on the stand and says, I didn't do it. Hypothetically, this is a hypothetical question. Toledo goes on the stand, he says, I had nothing to do with their killings. I have no idea what happened.
I mean, at this point, he might as well. They're trying every single thing under the sun. They're grasping at straws. He might as well go up there and say he was in Cancun that weekend. It's really, at this point, he's in my mind, the prosecution has already proven beyond a reasonable doubt that he killed the woman.
And the kids remain the other factor that we are not sure if they've really fulfilled their burden with respect to the kids.
I'm not sure they fulfilled the burden, but I'm convinced he did it.
Yeah, well, and maybe some of the other jurors share your impression. Of course, there is the possibility that Toledo could be convicted with respect to the murder of his wife, but not convicted with respect to the children. I mean, that's certainly a possible outcome.
Certainly a possible outcome.
But we don't know. Again, the jury, the story that the prosecution is presenting, coupled with, okay, so what do we have? We have the day before the victim and her children disappear, this violent outburst at the office relating to the victim's affair. Then we have a telephone call with her lover around 1 a.m. That's the last time we knew she was alive. We have hearing some commotion across the street by some neighbors later in that morning. Then we know that we have Tyshawn Jackson's testimony relating to the knock upon the bedroom window at 6:10 a.m. and then Toledo coming back to find law enforcement at his home later that morning. I mean, the timeline really fits in with a lot of the testimony in this story and fits into the prosecution's version of the case.
Just a coincidence. Just a coincidence, right?
Yeah.
Good luck with that.
Certainly a lot of problems. And then put this on top of it, you also have the confession in the interrogation tapes, which to me is, not to use the judge's words, we're talking about straw man, we're talking about finding a needle in a haystack. That is really the straw that broke the camel's back in that sense, because one, you have the defense up there in their closing argument saying, well, this is all circumstantial. We don't have a body. We don't have a murder weapon. We don't know how or when this person or these people were killed, and therefore there's reasonable doubt. If I'm the prosecutor, I'm like, well, we know exactly what happened because the defendant told us.
Yeah, on video, to the police, on camera. I mean, he basically gave it to them with a bow wrapped around it.
Yeah, it's a little bit of a mic drop moment for those prosecutors. So we'll see what happens as the case unfolds. Again, we're waiting for court to be back in session. There are 2 more witnesses on tap today for the prosecution, and then the prosecution will rest. After that, we know the defense is going to be putting on some witnesses, including a reboot of Tyshawn Jackson, 2 police officers, their impressions of Jackson's story, and potentially seeing a statement taken by police that will be relevant in Tyshawn's testimony. The defense wanting to have Tyshawn Jackson on the stand, or the police on the stand, excuse me, before they put Tyshawn Jackson on the stand with respect to all of these issues. So there is a lot to come. The court is still in recess. We do see that the judge has entered the courtroom, but nobody else is there. Toledo's not in there. The jury's not in there. So we're still waiting for court to reconvene. In the meantime, let's continue to review that story of Tyshawn Jackson. This is the story that's going to be at issue today. Who knows what else will come out in his testimony? We're going to throw to that prior testimony now while we wait for court to come back in session.
You were going when you left his house?
Where, excuse me?
Where were you going that morning?
Well, before he got there, I didn't know.
Were you following him?
Yes, sir.
In which direction were you following him?
We were going towards I-4. I don't know the direction, like longitude, anything like that. We're like going towards I-4 towards Sanford.
Is Sanford south of Deltona?
Yes.
Where did you think you were going that morning?
Honestly, I had no idea. I thought probably like somewhere close, a relative's house or something.
Were you aware that his mother-in-law lived around the corner?
Yes.
Were you traveling in the direction of his mother-in-law's house?
No.
As you drove towards I-4, tell us your perceptions. Tell us where you went, how you drove.
We drove past I-4, and then we started going towards 1792. Then we made a left on 1792 and drove all the way down, going towards Sanford, went over the bridge, and then made a left on, I don't know the, I think it's still 1792, I believe. And we just continued down 1792.
Was this a long distance from your home?
Yes, quite a way.
Was it further than you expected to drive that?
Yes.
Far? Where did you eventually end up?
We eventually ended up in a Publix parking lot by Seminole State College. It's community college in Sanford.
You recall how long it took you to get there?
I'd say like 20 minutes, 30 minutes.
When you arrived to the Publix parking lot, were you still following the defendant?
Yes, sir.
Okay. And what did you see as he pulled into the parking lot?
I seen him wiping out his car.
In
intends to rest today, and then the defense will be putting on their case. A critical part of the defense case, apparently, another day of testimony of Tyshawn Jackson, along with 2 other police officers who will testify as to their impressions of Jackson's story, and also some statement that was taken from Jackson, apparently, that had been at issue in the court prior to the jury coming back into the courtroom. We just received word that the jury is in the courtroom now, and it looks like court is back in session. So we're going to go live to the Florida courtroom. We're having a little bit of a tech issue in the courtroom with our feed, but we're hopefully going to be back on track shortly. Again, we're here in the Toledo courtroom anticipating the end of the prosecution's case today. I'm still here with Ken Belkin, who is a trooper, who is sticking with me through all of these sidebars, who keeps trying to leave, but I keep tethering him back to the seat saying, let's talk a little bit more about Toledo. So in this case, we know that the prosecution's going to rest today. Only 2 more witnesses, and then the defense is going to put on their case. We know about Tyshawn Jackson, the other police officers. Do you think there's going to be any more to this? Is there anything that they can do?
Tyshawn 2.0 is going to be a doozy. Honestly, this is very rare when defense attorneys will recall as one of their own witnesses someone who was a prosecution witness. This is going to be great to see in action.
Yes. So, Ken, as you said, this is rare.
I don't think I've actually ever seen it done.
And so what do you think the defense is thinking doing this? Because, again, just to explain to our viewers, when you have a witness on the stand, the prosecution called Tyshawn Jackson as their witness. They do a direct examination. The defense has the opportunity to cross-examine. Ken, why would, since the defense has already had that opportunity to cross-examine Jackson, what are they thinking bringing him back up on the stand, especially knowing that there is a risk that they could open a can of worms that they don't necessarily mean to?
Look, it all comes down to one thing. When they cross-examined him the first time, they were only permitted to ask questions that were within the scope of the prosecutor's direct examination. So now they're going to have a little bit more latitude in their questioning of him, and it's going to be some more open-ended questions. Now, the interesting thing is, first of all, it's sort of accepted in the criminal defense world that prosecutors don't always make the best cross-examiners. They're very good at direct, but very frequently defense attorneys don't put witnesses on, so prosecutors don't get that much experience and practice cross-examining witnesses. Now, this is going to be even double that because they are definitely not prepared to cross-examine one of their own witnesses. They probably don't really know what is going to be asked.
Right, and we know that it seems like there was at least some controversy between the prosecution and the defense about that testimony. The prosecution saying that they're going to object to the defendant improperly impeaching Tyshawn Jackson's testimony. The judge ruling that some of the questions the prosecution was talking about haven't actually been addressed yet.
Also, presumably, the prosecution's probably going to object several times on the basis of asked and answered, because I'm sure they're going to cover some tired ground of questions that were already asked by the prosecution and already answered by this witness previously when he was on the stand. So there's going to be a lot of objections probably. If I were the prosecution, I would just let him roll with it, because, you know, this guy is not their witness. He hasn't been prepared to testify on direct. He's probably going to open his mouth, and they're going to inadvertently open the door to some things that, you know, Mr. Toledo would rather the jury have not heard.
And that could absolutely be true, but is there a counter argument that the prosecution maybe was happy with the first round of testimony of Tyshawn and wants to keep it in that narrow box, or perhaps that there's something else out there we don't know about yet that the prosecution thinks is damaging, because clearly there's controversy surrounding it. That's now the second sidebar. We were scheduled to reconvene at 1. Then, you know, we move back to 1:30. Then there's further argument about the issue and all that. So what's out there, we don't know.
Look, the prosecutors should be pretty confident in their case right about now. They should be pretty confident. They're getting him on at least the murder of his wife. At least. Probably they're going to convict him on the murder of the children, too. Because he just looks like someone who did it.
Yeah,
unfortunately.
I mean, there's certainly a lot of issues. And if the jury buys that the victim, the mother, Toledo's wife, was murdered by Toledo, as per his interrogation video, then they may actually buy that he murdered the children as witnesses.
And by the way, if I was the prosecutor, in my closing, I would say that his denial of murdering the children is nothing more than an attempt to avoid jailhouse reprisals, because it's well known by people who, especially someone who's in a gang that has been to prison before, been convicted, knows people who's been to prison. It is well known that convicts who commit crimes against women and children, they are subject to jailhouse reprisals.
Definitely. That's common knowledge. That's a tough spot to be in.
So I don't think he wants it out there that he killed children when he knows he might be going to jail for something like 25 to life.
And that, just to close a loop here, Ken, that brings us back to where we started, square one, earlier today with this broadcast, with the question of defense strategy as far as opening that gate by saying, we don't have a body, then we don't have a murder because we can't pin this down. Was there a better strategy out there, especially knowing what evidence the jury was going to see?
You know, I think the defense attorneys are doing the best they can with a horrible fact pattern. It's just a horrible case, you know, and they're doing the best they can.
Yeah, they're doing what they can. And again, you're only dealt the hand that you're dealt. You can't recreate the facts. You can only work with what the